All right. Court is calling People versus Brendan Troutman in 25 CR 2239. If I can have appearances.
Holly Spees for the People.
And Brendan Troutman in proprio persona, all rights reserved.
All right. Ms. Troutman, last time we were here, you had informed the court you were still seeking counsel and you did not get the application for public defender's office even after the record was made if there was any changes to your finances. So how are you proceeding today?
Well, I'm forced to be going to trial on this, I guess, if this is the last arraignment. I do not have the funds to secure private counsel.
For the record, did you inquire the public defender's office again after your last arraignment?
Yes, my income hasn't changed. I've moved my budget around to accommodate a small savings amount to secure a private attorney. But yes, so I'm getting retainer fees of $2,500, $5,000, and $15,000. So that's
Okay,
just
so
not,
just for my clarification, you still don't qualify for the public defender's office?
I do
Is that what
not.
you're letting me know. Okay.
yes.
All right. Ms. Spees, any additional record for the people?
Judge, I believe at this point, Ms. Troutman and I have had a phone conversation, a few conversations before court on different dates. And so given that I believe we've given ample opportunity to apply for the public defender, we should proceed forward with setting trial dates. I did just want to make a Lafleur record, and I don't have in my notes that an Arguello advisement was done, so I'm not sure how this court would like that.
I advised her last hearing, Ms. Spees, right? I believe Ms. Davis was covering for you.
Thank you for letting me know. In terms of the Lafleur record, right now, as the charges currently stand, the defendant has been charged with 5 counts. Count 1 is F for assault in the second degree strangulation, and count 2 is F for kidnapping, seize, carry. Count 3 and 4 and 5 are all misdemeanor counts. Count 3 is assault in the third degree, and count 4 and 5 are misdemeanor 1 or child abuse, and count 5 is misdemeanor 2, child abuse. I met with Ms. Troutman in the disposition room before court today and inquired if she wanted an offer. She said no, she did not want an offer and she would proceed to trial. Given that, I just wanted to put on the record that if Ms. Troutman wanted an offer, what we have VRA compliance for is M1 assault in the third degree and M1 child abuse for a dismissal of all felony counts and the remaining misdemeanor count with an agreement to probation.
Thank you for that. Do you understand that that would be the offer if you were interested in hearing an offer from the district attorney's office, Ms. Troutman?
Yes, I heard what she said. And I do get that that would be the offer she would be extending to me should I choose.
Okay. And are you accepting that offer today?
No, I am not.
All right. The court will enter a not guilty plea. We will set this for a pretrial conference. I'm going to set this on my next docket day of May 26th. Ms. Spees, does that clear for you?
May I have 1 moment, Your Honor?
Sure.
I also have 2 things that I need to put on the record.
Okay, hold on just a moment.
Did you say May, Your Honor? Or
I did. In 2 weeks?
May 26th. Yes, I can accept that.
Okay. All right, that's in 2 weeks. Ms. Troutman, morning or afternoon?
Afternoon will work. You're saying, is this pretrial? What is this?
Pretrial conference is when you clear dates for motions, hearing, and a jury trial.
Okay.
Speedy trial will run from today as I have entered a not guilty plea on your behalf. Speedy trial 6 months. We will set motions, jury trial, as well as a plea cutoff within that time.
So I do want to put for the record, I have to request an ADA advocate for this because I am not formally trained in law. That puts me at a huge. Yes, I heard what she said.
All right,
And
buckle
I
up,
do
because
get that
today's
that would
courtroom
be
chaos
she
comes with a
would be
double
extending to
feature,
me
and
if I
trust
choose.
me, both
Okay,
of these
and
hearings
are you
take some
accepting that
turns
offer
you
today?
probably won't
No,
see
I'm not.
coming. In the first case, we're dealing with a defendant facing some extremely serious allegations. But instead of focusing on legal strategy, things take a sharp detour into constitutional claims, misconduct accusations, and arguments that leave the courtroom moving in one direction while the defendant seems to be operating in a completely different reality. Now here's where it gets interesting. The judge actually gives a surprising amount of patience. You'll notice something important as this unfolds sometimes in court. A judge doesn't interrupt because they agree. They stay quiet because they're simply letting the record speak for itself. And when legal jargon starts flying around, the real question becomes, is this helping the defense or making things significantly harder? Then, just when you think things couldn't get stranger, we move to a second defendant who starts off receiving an unbelievable amount of grace from the court. We're talking lowered bail, flexibility, encouragement about work, even opportunities to appear remotely. Sounds like a lucky break, right? Well, let's just say that goodwill doesn't exactly last forever, because somewhere between cooperation and confrontation, this situation completely flips. One hearing changes the entire tone, and by the end, promises made in court come back under the spotlight in a major way. So stick around, because this one has courtroom tension, legal misunderstandings, dramatic reversals, and a judge whose patience eventually runs out. And as always, I want to hear from you. When someone is given chance after chance in court, where do you think the line should be?
Yes. Secondly, at pretrial, do I have to, is that when I would have to have all motions for suppression and stuff in?
No, that's when I set the motions date,
Okay.
and those would be due 30 days prior to the motions hearing.
Okay. Also, am I allowed to put what I need to put on the record right now? Or do you want me to wait?
Go ahead.
Okay. I just want to draw attention to my notice of intent for seeking redress, my right to redress, actually. For the record, God-given right for motherhood was violated. Amendment violations, compelled being a witness against myself, clear evidence of investigation practices operating from a presumption of guilt, abusive process, judicial misconduct, prosecutorial misconduct, trespass, assault and battery, and wrongful imprisonment. And I will be seeking redress in accordance with the Supreme Court ruling Trezevant versus City of Tampa, and the fee schedule that is currently on record with the Denver County Clerk of Record. In accordance with 42 USC 1983, 18 USC 241, and 18 USC 242, notice is given.
All right, pretrial is set in 2 weeks. You're indicating afternoon setting. I can do a 2:30 if that clears with Ms. Spies.
Judge, I am in a motions and status conference at 1 o'clock in Division 500. We've already had a motions hearing, so I don't think it would take too long. But I fear if it goes past an hour and a half, then I may make this court late.
How about I do an 11 a.m.? Can you do an 11 a.m.?
11, yeah, that would work.
I can accept that. Thank
Okay.
you.
All right, Ms. Troutman, I will see you back on May 26th in this courtroom at 11 a.m. for a pretrial conference. The parties I do provide dates for jury trials and motions if you can clear that before I call the case.
Yes, Judge.
All right, we'll be in recess.
Pause
Yeah, I
right
can't
here
pull it up
because
on
there's
my
an
computer.
important courtroom
Oh, there-
moment happening
no.
beneath the surface.
Okay.
The defendant has just requested an ADA advocate,
There we
arguing that
go.
not being formally
All right.
trained in law creates a disadvantage in representing
We'll go on the
herself.
record in the matter
And to be
26
fair,
GF 89
representing
group file of
yourself in
Ryan
criminal
Locke.
court is
Appearances are we
incredibly
have
difficult.
the
Court
assistant district
procedures,
attorney appearing by
deadlines,
video
motions,
conferencing. We have
evidentiary
Mr. Locke
rules, none of
appearing
that
by
is
video.
simple. But here's the legal distinction the court is making. Lacking legal training is generally not considered a disability under ADA protections. Courts can accommodate recognized disabilities, but they don't usually appoint assistants simply because someone is unfamiliar with legal procedure. What's fascinating here is the contrast between practical legal reality and personal belief. You can already sense the courtroom moving towards scheduling and procedure, while the defendant appears focused on broader grievances and perceived violations. And that raises a huge question for viewers. If you're facing serious charges, is self-representation ever truly a smart move? Or does trying to navigate the system alone put someone at a massive disadvantage before trial even begins?
Has asked to withdraw. I usually do. I can't hear you or see you, but I guess that is you. Okay.
Can you hear me?
I can. Is there a button for you to be able to
start
push?
my video? Should I hit that?
Yes, please hit that.
Okay, there we go. All right, now I see myself.
Okay, I swear that you were put on this on the. I might have to refresh. GS. On May 21st, 2026, in which he appeared by video conferencing and was being combative and not complying with the court's process. The court ordered him to be here in person today at 2:45. He now fails to appear. What is the state requesting?
I would ask for a warrant.
In custody in Burnett County Jail. Mr. Locke was arrested a couple days ago. Bail was set at $500 cash with certain conditions. And then, Mr. Locke, I received your letter here today requesting that the court consider lowering that to $250. And in that letter, you say that you promise you'll do, you say, I promise that I will do right. You won't see me back here except for court. And so you're pleading with the court to lower that and to trust you that you're going to make your court appearances and engage in this process. Is that correct?
Yes, Your Honor. See, I've never missed court ever, and I had an interview today for a job that is in walking distance from where I'm living in Spooner, and I was not able to make that today, but I was hoping to get out so that I was able to call them today back and say, hey, I'm sorry about communication, but I'm very, very interested in that job. Is there a chance that I can still get it? Because I've been looking for work and it's been tough.
I hear you, Mr. Locke, and I don't want to interfere with your ability to get a job and to be able to provide for yourself, et cetera, because everybody deserves to do that and you should be able to do that. And you said it's within walking distance from your address?